yellow
Recording
blouse
in
with
progress.
black polka dots and circles around them. Welcome to this webinar training on how to appeal a LPS conservatorship. This training will be presented by Debbie Davis and me. Debbie, how are you doing this morning?
Oh, I'm doing good, ready to go. My name's Debbie Davis. My pronouns are she, her, hers, ea. I am a person with lived experience. In other words, I'm a mental health client. I'm also an older white woman with short brown blonde hair, green eyes, and I'm wearing a white shirt and a black sweater over it.
Before we get started with today's training, I have a couple of announcements. So first, I would like to describe a little bit the slide I have on the screen. There's a blue box on the right side that says you have the right to advocate for yourself. Underneath the box, there's a person looking at themselves in the mirror, and the mirror is taking out the image of the person and pointing at the person. Also, live captioning is available. If you would like to access this feature, please use the option located on your screen. We also have a sign language interpretation available, and questions or comments made throughout the presentation will be recorded, so nothing said will be confidential. At the end of the presentation, we will stop the recording and we will take live calls so that you may ask questions outside of the recording. The recording for this training will be available in a couple of weeks. Later in the presentation, we will provide you with a link where you can access the recording.
Disability Rights California is California's protection and advocacy system. Our mission is to defend, advance, and strengthen the rights and opportunities for people with disabilities.
Disability Rights California has different units. Debbie and I work for the Peer Self-Advocacy Program. Here on this slide, we have a list of the services we provide. We facilitate self-advocacy groups in mental health facilities and state hospitals. We provide trainings to people with significant mental illness and to mental health service providers on legal rights and access to services. We also help participants develop self-advocacy skills and strategies to advocate for their own goals and services. On this slide, we have some disclaimer statements. During this training, we will not be providing legal advice because this training is being provided from a peer perspective. Debbie and I are persons who have lived experience with mental health disabilities, and nothing said during this training is confidential. If you have a disability-related legal issue that you would like to discuss with Disability Rights California, please call our intake line at 1-800-776-5746. For TTY, 1-800-719-5798.
Today, we're going to talk about just an overview of what is LPS, Latimer Petra Short, conservatorship process. We'll go on to tell you about third-party assistance and how you can appeal being put on conservatorship, either through a rehearing petition or by filing a writ of habeas corpus. And we're also going to show you how to develop an action plan to show that you are not gravely disabled.
So let's begin with LPS conservatorship. LPS conservatorship is based on the Latimer Petra Short Act that went into effect on 1969. Named after its author, State Assemblyman Frank Latimer, and California State Senator Nicholas C. Petrus and Alan Short. An LPS conservatorship gives legal authority to one adult called a conservator to make certain decisions for a person with serious mental illness called a conservatee who is gravely disabled. LPS is governed by the California Welfare Institutions Code. Codes. Throughout the presentation, we will reference these codes and sections. LPS conservatorship is a court process. A judge or jury decides if the person is gravely disabled and need to be on a LPS conservatorship. So what does it mean to be gravely disabled? Well, it means that because of a mental disorder or chronic alcoholism, you cannot provide for or take advantage of food, clothing, and or shelter. Well, this is, you can find this in the Welfare Institutions Code 5350.
Kind of how an LPS conservatorship gets started is if your doctor or a professional care provider, such as a social worker or mental health, licensed mental health worker, believes that you may be gravely disabled, they can make a recommendation to the public guardian's office to start a conservatorship investigation. What happens next, slide, is that the petition, actually the thing that says, we want a court hearing, would happen after the conservator investigator goes and talks to you and talks to other people and then kind of decides whether they have a good reason to believe that, yes, you are not able, because of a mental health disability or chronic alcoholism, to provide for your food, clothing, and shelter. During the investigation process, excuse me, the public guardian must investigate all alternatives to conservatorship. And the conservatorship may be established or the petition may be filed if there is no less restrictive means to be able to help a person out so they would be safe and be able to have food, clothing, and or shelter. So my question is to people that, have joined this webinar, have any of you been on an LPS conservatorship? If you can just type yes or no in the chat box. Okay, let's see. No, somebody said no. Okay. Okay. Well, we all know about probably everyone's sort of heard about the case about Britney Spears. She was found because of a mental health disorder. Sorry about that. I'm working from home and my roommate didn't pick up the phone in time. I apologize. Any rate, so we all know about Britney Spears. And she was on conservatorship for something like 11 years. And certain rights had been taken away from her. She was told where she had to live. She wasn't allowed to vote, maybe not drive a car. But you look at Britney and it's like, well, she's got lots of money. So she has food. She's wearing clothes. Maybe she had an issue with food. I don't know, but she actually had to ask the judge permission to hire her own attorney who was able to get her off LPS conservatorship. It's not an easy thing once you get put on it to be able to prove that you're no longer gravely disabled. So if you do wind up, if the public guardian actually sends a petition to the court and says, like for me, they want to have a conservatorship hearing on Debbie Davis because we believe that she is gravely disabled, then I am entitled to have a hearing within 30 days of the time that the petition was filed with the court. Now, if I decide to fight it, then it might take up to 6 months before I could actually have the hearing. Why the difference is, I'm not sure. You also have a right to demand a jury trial instead of having what we call a bench trial. A bench trial is when the judge hears the evidence and then they decide whether you fit the criteria for being on conservatorship or not. A jury trial, it will be 12 citizens, and the burden of proof is the highest there is, which is beyond a reasonable doubt. And it's up to the county to decide, to prove, not decide, I'm sorry, but to prove that you are gravely disabled. It's the burden of proof is on the county. It's not on you or your attorney. It's on the county. So that's kind of how LPS conservatorship gets started. And I'm pretty sure how it gets started and how to appeal, but I'd like to turn it over now to Maria, who can tell you about third-party assistance, which is an alternative to conservatorship.
Thank you, Debbie. Yes, let's talk about third-party assistance. So third-party assistance can help during the initial hearing process. Third-party assistance is when family, friends, or others are willing to check in on you and make sure you have food, clothing, and shelter. The third-party assistance can be used to show the court you are not gravely disabled. If someone is willing to do this and the court approves that person, then you are not gravely disabled, right? And you do not need to be on conservatorship. Who can be a third-party assistant? So let's say you're living in a boarding care home. You're discharged from an acute hospital and your treatment team recommends placement in a boarding care home or outpatient treatment. While waiting for your LPS conservatorship hearing, you are wondering who can be my third-party assistant? Well, the third-party assistant can be a family member, a friend, or other person you trust and believe they can help you. But the person who manages the boarding care home cannot be your third-party assistant. If a family member or friend wants to become your third-party assistant, they must write a letter to the conservator, judge, and attorney, telling them they are willing to help you. You need to include in the letter their contact information. Ask the person to come to court and testify about how they will help you. You may want to take a copy of the letter to court and ask your attorney to have the letter entered into your case record. Your third-party assistant can agree to stop by and check on you. They may offer to take you shopping, to medical appointments. They may be able to help you find good community resources such as food banks or community shelters that can help you stay off conservatorship. Also, your third-party assistant may be able to help you by taking you to the Social Security office so you can apply for benefits. It is a good idea to keep the communication flowing between you and your third-party assistant so they know what your needs are and how they can help you. Document the things your third-party assistant can help you with and present them to the judge at the court hearing. Things to keep in mind. They can suggest things, but they cannot make you do anything. You are not their responsibility. You do not have to live with them. And then the difference between third-party assistance and LPS conservatorship A third-party assistant has no legal right to make you follow their suggestions, and a conservator has the legal right to make decisions for you. So that's the difference. A third-party assistant, no legal right to make decisions, to help. They make suggestions, but they don't enforce them. And a conservator has the legal right to make decisions for you. And the court can refuse a third-party assistant if they feel the person will be unable and or unwilling to help you, or you would be unable to live safely with their help. That is why it's important that you choose someone that is willing to help, that will be there for you. And the court can decide to place you on a full conservatorship despite your offer for third-party assistance. The reasons for doing so should be on the record. This means that they should be documented during the hearing when the judge is stating the reasons. However, you can appeal the court's hearing decision. So now that we know you can appeal the court's hearing decision, Debbie, can you tell us how can we appeal?
Absolutely. And I encourage you very much to appeal if you don't want to be on the conservatorship and you lost your LPS conservatorship hearing. One, you can appeal, but you got 60 days to do that from the time that you were placed on conservatorship or your conservatorship was renewed. You can tell your attorney that you want a rehearing to appeal the conservatorship, and they'll do the paperwork that's necessary to make that happen. You can also write the court and say that you want a rehearing, and then you'll be appointed a public defender if you can't afford one, and you'll be given a date when your hearing will be. After 60 days of being put on LPS conservatorship or having the conservatorship renewed, you would have to wait 6 months before you can again ask for a rehearing and ask to be off LPS conservatorship. Next. At the original hearing, like I said a couple of slides ago, it's the county that has the burden of proof to show that you really are gravely disabled because of a mental disability or chronic alcoholism. It's totally different at the rehearing. You, via your attorney, has the burden of proof to prove that you are not gravely disabled. And there is no right to a jury trial. You will have a bench trial, which means the judge will hear the evidence, and then they will decide whether, because of the evidence presented, whether you are in fact, according to the law, gravely disabled. What I want to share with you is an action plan to show that you're not gravely disabled. Whether you use this if you're first being put on conservatorship and show your attorney, whether your conservatorship is being renewed, or whether you're appealing your conservatorship. On paper, it's really important to show how you're going to provide for your safety and how you are going to get food, clothing, and shelter. You write things down like what your monthly income is. Where are you going to live, and how much is the rent are you going to have to pay? And how are you going to get food? And how much might it cost a month for you to buy your food? And this sounds kind of silly, but clothing is part of the grave disability definition. What clothes you have. For me, if I was writing, I would say I have 3 pairs of pants, 2 pairs of shorts, 5 t-shirts, 10 socks, a bunch of underwear, and 3 pairs of shoes. I would actually put that in my action plan. And then if you are willing to receive mental health treatment, I would put that on paper, that you're willing to receive mental health treatment. And if you know where you would get that treatment, it would be really good to put that down. And also, how are you going to get to different appointments? How are you going to get around? Again, you're addressing in the action plan food, clothing, and shelter. Here's a written example of how that might look. Let's say we're talking about me. I get SSI and I get $1,040 a month. And I write in the action plan that I will live at Friendly House Room and Board, its made up name, as you can tell, in Sacramento. The rent is $800 a month and 3 meals a day are included in the rent. I'm going to buy a monthly bus pass for $50 a month. I'll be able then to take the bus to see my psychiatrist at WellSpace Clinic. There, I'm letting them know I'm willing to go ahead and get mental health treatment and where I'm going to get it. And then I say, and other medical appointments. I'll use the bus to go to church, to see my family, and definitely to see my friends. And I want to save $20 a month to buy a bicycle because and that'll take me about 5 months. So when I do get the bicycle, then I could still take the bus, but I don't have to worry about the bus schedule. If I want to go over to my friends, at 2:30, and it only takes me 10 minutes to get there, I don't have to catch the bus because it only goes at 2 or at 3. I have more freedom where I can do things. So my income is $1,040 after paying rent, $800, which includes my food, getting a bus pass for $50, and saving for a bicycle. I have $170 left each month. That's not a lot of money in these days, that's true. But if I need to buy some clothes one month, or maybe I'm going to go out to a restaurant and have something to eat one time a month, or be able to go to a fast food restaurant, or maybe I want to go to a movie. I probably can't do all that in the same month, but at least I have extra money. And in this example, I have addressed food, clothing, and shelter, how much it costs, and how I'm going to get it. And if you wanted to do you don't have to do a spreadsheet, but this is how it might look. On your right is $1,040 dash income. On the left, it's a 2-column, for those of you who may be on the phone, it's a 2-column little spreadsheet. So on the right is the income. On the left are my bills, $800 dash rent, $50 dash bus pass, $20 dash bicycle. That all adds up to $170. So on the right column, I have the $1,040 income. Then I subtract $870 dash expenses. And then the money left is $170. Okay. Now I want to move to another way that you can appeal being on LPS conservatorship, and that is through the writ of habeas corpus. It's Latin for bring the body forward or bring the body. There's different variations as to what it means, but it's a legal form that you send to the court. You write why you don't need to be on conservatorship. State the facts. How are you going to get food, clothing, shelter? What is your income? Where are you going to get shelter? How much is it going to cost each month? Where you're going to get food? How much it's going to cost each month? And then also what clothes you have, or that where you can get clothes. It's totally up to you. What I want to emphasize is do not do what I call throwing in the kitchen sink. This is where someone might write on their writ, I'm not gravely disabled. I don't need to be on LPS conservatorship because the judge had it in for me and my mother paid him $100 to put me on conservatorship, or everybody's against me. They're out to get me. And if I could get off conservatorship, I can get away from everybody. Or going into great detail on how you wound up on conservatorship. That's not what a writ of habeas corpus is about. It's about saying why you don't need to be on conservatorship, why you are not gravely disabled, and addressing food, clothing, and shelter. If you throw in the kitchen sink, more than likely they're going to glance at your writ and send you a notice saying, writ denied. So the court, once they get your writ, can do one of three things. They can find in your favor. They can read your writ and go, wow, okay, well, yeah, okay. And they'll send you a note saying, okay, you're off conservatorship. That rarely happens. Or they can write you and say, we got your writ, we read it, we got questions for you, and ask you to come to court on a certain day at a certain time to kind of say more why you are not gravely disabled. The third option, flatly, is to deny your writ. You'll get an official letter from them saying, we got your writ and it's denied. Sometimes they will say why, like if you could have gone through another step before you went to the writ of habeas corpus, which really doesn't apply in this particular instance. You can ask your attorney about the writ of habeas corpus, and you could ask them to help you fill out the writ.
Debbie, I have a question.
Oh, okay.
Is LPS conservatorship the only thing we can challenge?
Absolutely not. When you're put on LPS conservatorship, your conservator tells you where you're going to live. The judge may take away certain rights, such as the right to vote, the right to live where you want. That comes automatically with the conservatorship, the right to live where you deny the right to live where you want, signing a contract, driving a car, those sort of rights. You can look on your conservatorship papers and read through it, and then you'll see a section that says disabilities. Why they call this, I have no idea, but it will list the rights that have been taken away, if any. You can write the court, like for instance, the right to vote. You can write the court and say, I want my right to vote restored to me. I've read my ballot. I understand, and this is my right as a U.S. citizen to vote. And may I please have my right to vote restored? The same thing you could say with driving a car, or contracts, or whatever rights have been taken away from you. So if you had a rehearing, you have to wait, and you lost, or you didn't file for a rehearing within 60 days, you have to wait the 6 months before you can ask for another rehearing. And also, same thing with a placement review hearing. Let's say that your conservator puts you in a locked facility and you feel, no, I don't need to be in a locked facility. I'd rather be like in a board and care or a room and board or out on my own. You can ask for a placement review hearing, and then your attorney will also help you formulate what you want to say and why you can live in what they call a least restrictive environment, that you don't need to be in a locked facility. You can do that every 6 months. So, and just as a note, if you live in a board and care on conservatorship, please know that more than likely, if you're off conservatorship, if you like the board and care and you want to stay there, you can, even if you're not on conservatorship. Any rate, so Maria, could you talk about reestablishment?
Yes.
Thanks.
Certainly. Okay, so LPS conservatorship lasts 1 year. It can be renewed every 12 months. Before the 12 months are up, your conservator can write the court and say you are no longer gravely disabled. And at that point, the conservatorship will end. Or the conservator may tell the court you are still gravely disabled, and the court will set a reestablishment hearing. If your conservator will be seeking a reestablishment of your conservatorship, you can choose to oppose or fight the reestablishment decision. But again, be prepared to tell the judge how you would be able to provide for food, clothing, and shelter. Debbie, this brings us to the end of the training. During this training, we learned about the initial hearing for LPS conservatorship, third-party assistance, and how to appeal the hearing decision. Lots of good information, right? So now let's talk a little bit about resources. So if you need more information, so the resources, GRC Publications website. You can find lots of great publications that have information about different topics on our disability website. And you can visit rights, CA, one word, .org/publications. And some of the publications that we're recommending for this training are Challenging LPS Conservatorship, Understanding the LPS Act, and Fact Sheet on Third-Party Assistance. And also, if you need more information about any welfare institutions code mentioned in this training, you may want to visit this website, the California Legislative Information website. And for this, you can follow the link, legislature.ca.gov. And you can enter the code in the section in the quick code search option. For example, the section would be WIC for Welfare Institutions Code, and the section can be 5350. So that's a good resource there.
And if you want to contact Disability Rights California, if you have a disability-related legal question, you can call our confidential intake number at 1-800-776-5746, or for TTY, call 1-800-719-5798, or you can visit our website at www.disability, rights, RIGHTS, then CA, it's all one word, the CA is for California, .org. Our intake line, our confidential intake line, is open Monday, Tuesday, Thursday, and Friday from 9 a.m. to 3 p.m. We do not take calls on Wednesdays, weekends, or holidays. And any of our services are free, and we don't care what your immigration status is. So give us a call if you have a disability-related legal question.
If you would like for us to provide more information on a training we have given or have suggestions, please write to us at our email address, which is capital P, capital S, capital A, at disabilityrightsca.org. Or to view past webinar trainings, visit www.disabilityrightsca.org/events.
Okay, and that's for past webinars. I'd like to tell you before we go to our questions period, what our future or upcoming webinars are. This Thursday at 3:30 p.m., we're hosting a webinar, What to Do If You've Been Discriminated Against. On the 21st at 4 p.m., we have this same webinar, but presented in Spanish. And I'm sorry that I don't speak Spanish, so I can't pronounce. I know the first word is como, but the rest I don't know. It's the same webinar, but it's all in Spanish, which is awesome. And then on the 26th, we have rights and resources for transgender and non-binary rights in the mental health system. That's going to be, all these webinars are right on mark and up to date. And then on the 27th, which is a Wednesday at 1 o'clock, we're going to have a webinar on voting rights. We have our June primaries coming up. So if you'd like more information on your rights as a person with disability or not disability, come and join this webinar. And then on the 28th, which is a Thursday at 4 p.m., we're going, Zenobia Pichardo, one of our trainers here in the same team as I am, she's going to interview an individual named Leo who identifies with the LGBTQIA+2 with that particular group. So I hope, and you go the same way, you go to our website, www.disabilityrightscalifornia.org, you click on events, and then the registration for these webinars will be there if you want to join some of them, just like you registered for this one. Now I'd like to turn this part over to our question and answer. If you have a question or a comment, go ahead and raise your hand by clicking in the box that says, what does it say, Maria?
It says, use the Q&A box on your screen to put in your question, or you can raise your hand. So Brent can give you the permission to talk. And if you're connecting by phone, press *9 to raise your hand and *6 to unmute. So any questions or comments?
Yeah,
Recording stopped.
Okay. Yeah, we have stopped recording just to, so you don't have to worry about it recording. Leah, I see that you have your hand raised.
Thank you.
Okay, we actually have multiple questions in the Q&A box that were posted prior to this. So if we want to,
I don't see a Q&A box.
I can.
Could you help out? Yeah. Well, Leah has her hand up, and then we'll go to the ones in the Q&A box, if that's okay.
It's also in the Q&A box, but basically when I was on
Leah?
Oh, can you hear me? Can you hear me?
Yes, I can hear you. Welcome.
Thank you.
What's up?
Sorry, it's okay if you aren't able to answer this, but we're in San Diego County, so we've had this issue, me and a couple other people, and I'd like people to know, so when we were on LPS conservatorship and we asked for a writ after the initial permanent conservatorship was established, they said we were not allowed to have writs because those were extraordinary relief proceedings, and because we basically only had the rehearing as an avenue to challenge a conservatorship after the permanent conservatorship was established and letters were issued. So I just would like you guys to be aware that that's a problem.
I really would like to encourage you, Leah, because it is a legal question, and neither Maria or I are lawyers. I would absolutely want to encourage you to go ahead and contact our confidential intake line that we talked about. I'll go back to my notes and see if I could bring the number up again. That I don't know if legally they can do that. If it's not legal, if you do have a right to the writ, then maybe one of our attorneys can talk with you and see about how to do some education. Do you have paper and pen? Because I can read the number again to you.
Oh, I have it saved, but anything works.
Okay, good. Yeah, please. We're not open on Wednesday, though, but you can call today. Please let us know that this is going on.
Oh, it's in the comment, I in the chat box, I left the citation that the lawyers most frequently rely on in proving and explaining this to us as consumers. So, I just wanted you guys just to know. I don't know about other counties, but in San Diego, they're routinely denying it.
But please, if you will, give us a call, because we're just in the peer and self-advocacy unit. There's the mental health practice group that needs to know about this, and they prefer to hear from someone that it happened to or that you know about, where our stuff is just secondhand. We can sure pass it on to the mental health practice group, but it would be so much more effective if you would just give a call to our confidential intake line.
And then I have a second, more personal question, having been on LPS
Sure.
conservatorship, not legally. Do you guys have any evidence, any stories or advice if a conservatee AWOLs, will the public conservator really come after you, or will they just dismiss the conservatorship?
That I don't know.
That's okay.
No, our attorneys would know.
Okay.
They would know what's in the law, in the legal stuff, which I'm not familiar with. I don't know if they would come after you. I know that a couple of times I wasn't on conservatorship, but I didn't like the hospital I was in, and I, quote, eloped, and they sent the cops after me.
Oh, I'm sorry.
That was no fun.
Yeah, I'm sorry.
But it was nice to get out and get some air, even though I was brought back in handcuffs.
Thank you, ma'am.
Thank you very much, Leah, and thank you for posting what they said. And please, if you would, I'll let mental health practice group know, but it'd be so much better if it came from you or somebody else who had that issue.
Okay.
Thank you. Brent, what's in the Q&A? Because I can't reach the Q&A.
Okay, so we just a few comments. One question. It's easier to get into trouble than to get out of it. Just like conservatorships, it's easier to get put on conservatorship than to get out of it.
So true. That is so true. So many people who have come to self-advocacy groups that I have that I've facilitated, it's like, especially in abortion cares, they've been on conservatorship 4 years, 5 years, 10 years. Britney Spears was on it 11 years. Whoever made the comment, you're so right. It's easy to get put on it. It's very difficult to get off of it. But now a tool which is called third-party assistance. Any others, Brent? Or Maria?
Another comment is conservatorship courts sound similar to criminal cases. For jury trials, do we have a right to have a jury made out of my peers? Who would pay for our lawyers in those courts? If the county is fighting us, do they also pay for our legal team?
Okay, usually what happens is, no, there's no charge to you unless the court has determined that you can afford your own lawyer. Usually when the hearing date is set, you're assigned a public defender. Thank you. Go ahead, Maria.
Oh, no, I was just saying a public defender. Sorry.
Yeah, and there's no charge. And what's the other part of the question? I'm sorry.
That was it.
Well, what was the first thing said? Could you read it just one more time, Brent?
Conservatorship court sounds similar to criminal cases. For jury trials, do we have a right to have a jury made out of my peers? The second part is, who would pay for our lawyers in those courts? If the county is fighting us, do they also pay for our legal team?
I've often thought that you are entitled to a jury of your peers means, like people with mental health disabilities, or if I'm a Latina, it would be a Latina jury, or if I'm African American, if I'm a person of color, but that's not how they look at it. A jury of my peers would be somebody who's 18 years old and older and has the ability to hear evidence and make a decision. So it's a misnomer, at least in my opinion, that you have a right to a jury of your peers. And for me, it would be, a person with a mental health disability. So, you have a right to a jury, though, and they have to prove beyond a reasonable doubt, which is the highest standard of evidence, that you are, in fact, gravely disabled because of a mental health disability. Good questions. Any others, Brent?
We have no others in the Q&A, and the
Okay.
participants none of the way as their hands raised.
Thank you so much, everyone, for attending, and I hope you check out our future webinars. Maria?
Yes, thank you. Thank you. We appreciate your participation and for you guys to be here with us. We just have a last statement, which just says you have the right to know your rights. And before you exit the training, please answer 3 simple question survey. And we appreciate you for being here.